Lawsuits of any kind, family law, criminal defense, injury cases, are resolved one of only two ways: by agreement or settlement, or by trial. Now, I'm characterizing motion hearings like a motion to dismiss or a motion for summary judgment as trial because that involves a dispute that's taken to the courtroom and a third-party judge makes the ultimate decision, in contrast to a resolution by agreement, including agreements reached at mediation and collaborative law, which is a process designed to reach resolution between the parties privately outside of a courtroom. Those are the only two ways that cases are resolved. I've told this to clients, and some clients grasp it quickly and understand that they have to work toward either a resolution by agreement or prepare for court. And I've had other clients get really upset and even seek second opinions because they don't like the idea that they may end up in trial even if they don't want to. But there are two options. You have to understand that you have limited control over how this thing will shake out because you don't completely control the other side's behavior and perception of the strengths and weaknesses of their case. So you may feel like their case is frivolous or that they don't have any evidence or grounds to go against what you're asking for, but you still may end up in trial because they have their own decision-making process to go through just like you do. So you have to understand that even though you may be working towards settlement, even though you may feel like your case is one that should be resolved between the two of you privately by agreement without a judge or a jury getting involved, that may not be the way that it ends up. You may end up in trial even though you're making your best efforts to resolve it. We have designed a proprietary process to maximize our clients' chances at successful settlement while at the same time preparing for trial at all times. That way, if there's no deal, then you're set up and ready to go to court and to get the best option available to you. So I'm going to go through that with you right now. This is a linear timeline representing the process of a case. No matter where you're at when you come and meet with me, if you have trial in 2 days, or if your case hasn't even been filed, when I draw this timeline out, you are always right here in this process. And at the end here, again, whether it's in 2 days or in 2 years, this is resolution. And it's either by settlement or it's by trial. I'm going to repeat myself saying that over and over again because you have to be clear. Those are the only two ways that your case is going to be closed. So you are here right now. You need to gather information, and your access to information is going to vary depending on your circumstances. But the way I demonstrate that is your information gathering and disclosure needs to move like this throughout your case. Lawyers do not know this. They do not teach us this in law school. We put this process together after working through injury cases, criminal defense cases, and best practices for family law cases. So here's what the process looks like. You have to gather your evidence early on to make evidentiary disclosures. There is a rule of evidence that evidence can be excluded from trial, even if it's relevant, good evidence, if it was not disclosed. You are not supposed to be allowed to ambush people at trial with evidence that the other side hasn't seen. So to put that another way, they are entitled to it anyways, so you might as well give it to them early. You do not want your evidence excluded or dismissed by a judge or jury because the other side can truly say, I've never seen that before. Do not do that to yourself. So this represents information gathering and disclosure. We are one of few law firms who understand that. Lawyers do not understand the consequences of that rule of evidence I just described, so they play games to run up big fees and to drag a case out. You don't want to do that. At some point on this timeline, you will feel like you have enough information, even if you don't have all of it. You'll feel like you have enough to make a settlement offer. When possible, when we make a settlement offer, we try to make it as detailed as possible. We will even write a complete court order that represents the settlement offer. Sign here if you agree. Practically, very few people settle and agree here. But This is part of the process, and I'll explain why we do it like this. At some point when discovery is complete, you'll be required to go to mediation. Even in civil car wreck cases, judges can order you to a settlement conference, and even in criminal cases, in a pretrial hearing, the judge may require the prosecutor and the defense lawyer to meet in the judge's office or to talk in the hallway to explore options by plea, because they want to make sure that trial makes sense, that we've done everything that we can to resolve the case before we set it for trial. So we make a settlement offer early to try to frame the other side's perception of the case, to show them, along with the disclosures that we made, that we feel good about our case, that we have a solid basis for how we think the case should be resolved, and to set us up for mediation. So when we go into that mediation or settlement conference, we provide the mediator with our settlement offer and with 2 or 3 of our best pieces of evidence that we feel support the settlement offer. This lets the mediator know we are prepared, we are reasonable, and we have a stake or an interest in the mediation and negotiation process. A lot of times when we send the mediator our settlement offer, the other side's never even responded or made a counteroffer to our offer. So in a typical mediation session that lasts 3 or 4 hours, the mediator will be in our room with me and my client 30, 45 minutes. That doesn't mean they're not working for us. Actually, it means they're in the other room working on the other side saying, hey, it looks like they have a basis for what they're asking for. What do you have to say about this? And if you don't agree, why? And what do you have to show about why your position's more reasonable or should be more acceptable? So we settle a lot of cases here in mediation, and we settle a lot of cases after mediation in this gap before trial because of the difference in the way we handle our process and a lot of other lawyers. And I'll tell you what I mean by that. Most lawyers don't start this information gathering process until after mediation fails. So there is an inherent inefficiency in their process because they haven't really been thinking about trial. They've never distilled this and recognized and communicated to their client, if your case does not settle, the only other way for it to be resolved is by trial. That's it. There's one of 2 ways. So they then start thinking about trial, and we are months, sometimes years ahead of them because we have been thinking about trial from day one, because we know we want to settle the case. We want to make a good settlement offer, but we're going to make our best settlement offer when we have all the information that we need to make that offer. And that means preparing for and thinking about trial. What good, strong, admissible evidence do we have to incentivize resolution by agreement? And at the same time, if for some reason, whatever the reason is, the other side won't agree, we can then say, okay, we're ready for trial, and we file motions to set trial shortly after mediation every time because we are ready. We've been getting ready for a long time as soon as we've been engaged in the case. Now, I said this is you even if trial's in 2 days. The same concept applies. We get hired before trial, sometimes weeks and days before trial, but we're still thinking the same way. We just have a much more condensed timeline. But we have had some success in going in and adding evidence that was left out by previous lawyers who weren't thinking about trial. We cannot guarantee that, obviously, because there are deadlines that go into effect whenever trial is set. So sometimes we're successful that, sometimes we're not. But at the same time, we're trying to address that rule of evidence and make sure that nobody can claim that they haven't seen it. So sometimes a few days before trial, we get hired, we ask the client, give us everything that you can think of. We'll give it to the other side. Sometimes it's redundant, sometimes it's overkill, but we want them to say, okay, I acknowledge I have all this, or sometimes they'll be the ones who ask for a continuance, even though we may be the ones who actually need it, because they're now realizing, okay, we do have a case. Maybe this information wasn't highlighted or emphasized enough, but we're working to get that together to get ready for trial on short notice. Now, the converse is not true. If you think your case should settle, and so all you work toward is settlement and you do the bare minimum, you are not ready for trial if settlement fails. That's why our process works by thinking about trial from day one as opposed to thinking about settlement from day one. We're going to have multiple chances to settle your case if we're working it up for trial. But you want trial to make sense. And the only way trial makes sense is if you've done everything that you can to avoid trial. And the way that you avoid trial is by settlement, by negotiating in good faith, and by putting your case together so the other side sees, if we don't settle this, they are prepared for court. Most people don't get that. Most lawyers don't understand that. And so there's this inherent inefficiency and extra cost with trial prep that we've done throughout our representation earlier in the case.